Good morning, everyone. Today we'll be studying about the resignation of director. Resignation of director is given under section 168 of the Act. Along with Rule 15 and Rule 16 also need to be studied. Let's understand what's the process of resignation of a director, how the director resigns from his office. A director may resign from his office by giving a notice in writing to the company. So the notice means the resignation letter should be in writing, and the board shall, on receipt of such notice, take note of the same, and the company shall intimate the registrar in Form DIR 12. So after board will receive the resignation letter or notice of resignation from a director, right? It shall take note of it means that it will be noted down in the minutes of the board meeting, and the company shall intimate to the registrar. Registrar means the regulator. Registrar is the Ministry of Corporate Affairs who regulates the affairs, company affairs, right, or corporate affairs. So ROC is being like every state has one registrar, right? And under the jurisdiction of the state boundaries, whichever companies are being incorporated, the regulator of that company is that registrar. So we also have a registrar at West Bengal, that is registrar of companies West Bengal, whose office is in Kolkata. So the company has to intimate to the registrar, and intimation will be going by filing an e-form, electronic form, in the website, that is the MCA portal, right? So the form number need to be remembered. So in which form the company has to give to the registrar and intimating the director's resignation, it is Form DIR 12. DIR 12. Within how much time it should be going with the registrar? It is within the 30 days from the date of receipt of notice of resignation from a director. So Form DIR 12 need to be filed with the registrar by the company within 30 days from the date of receipt of notice of resignation from a director. So we understood one compliance, that whenever a director resigns, director has to give a notice in writing. So it should be a written resignation letter. To whom it will be served? It will be served to the board, right? And board will receive it and also note it down that such and such director is planning to resign, right? In the minutes of the board meeting, and plus the registrar need to be informed with the help of this form, that is Form DIR 12, and plus the resignation of a director thing also need to be mentioned in the website of the company, so that the investors and other stakeholders come to know. A director. So this was the part one of the compliance, where the company is doing whatever the compliance is required under section 168. Now we'll understand that few compliance the director himself also, who is resigning, has to also do. So what is his compliance list? First one, the director who resigns from his office, he may, within a period of 30 days from the date of resignation, forward to the registrar a copy of his resignation along with reasons for resignation in Form DIR 11 along with the prescribed fee. So director also need to file one form with the registrar. It is Form DIR 11. Timeline is 30 days from the date of resignation, in which he will be mentioning the reasons for resignation, right? And it will also go to the MCA portal to the registrar. All these two forms has a prescribed fee, right? And it's a fee of rupees 600. Normal fee. If delay happens, that it's more than 30 days, it takes to file a form, right? Be it DIR 11 or DIR 12, additional fee will be charged, right? But normal fees is 600. In case a company has already filed DIR 12 with the registrar, a foreign director of such company resigning from his office may authorize in writing a practicing company secretary or a chartered accountant or a cost accountant or any other resident director of the company to sign DIR 11 and file the same on his behalf, intimating the reasons for resignation. So we should understand that uh, in the companies who are incorporated under in India under this act, the Companies Act 2013, few directors may be foreign directors, means they are foreign nationals, foreign resident, right? Both. So it can happen. So here, if a foreign director is resigning, means a person who is not a citizen of India, who is a citizen of some other foreign country, and who is a director in Indian company incorporated under this act. So if he is resigning from his office and the company itself has already filed DIR 12, right? Then we have a this foreign director has a relaxation. He can assign any, means give a power of attorney to any of these professionals or the resident director of the company who will be filing DIR 11 on his behalf, on the behalf of the foreign director. So who are the practicing professionals? These all practicing CA, CS, CMA or any resident director of the company can file the form on behalf of the foreign director if foreign director has given an authorized special power of attorney to that concerned person. Fine. Also in DIR 11, the reason for resignation will be mentioned, which we have learnt earlier. Now we will be learning about the about the date of resignation, how to fix the date of resignation. The resignation of a director shall take effect from the date on which the notice is received by the company, or the date, if any, specified by the director in the notice, whichever is later. Means that there are two dates need to be understood, and we'll first find out the dates, and then whichever is later date will be chosen, and that date will be the date of resignation. So date on which the notice was received by the company means the date on which the resignation letter was received by the company. And the next date is the date, if any, which is mentioned in the notice. Means if the notice is received by the company on 1st of June, fine. On 1st of June, the notice is received by the company. But inside the resignation letter, it is being written that the concerned director will be resigning from 15th of June. So, which is the date of resignation? The date of resignation will be 1st June, on which the notice of resignation received, or the date which is mentioned in the notice was 15th of June. So, which date we will choose? We will be choosing the date whichever is later. So, it is a later date, means 15th of June is the date of resignation. Provided that the director who has resigned shall be liable even after his resignation for the offences which occurred during his tenure. This means that the resignation is not a kind of a immunity which a person will get after he resigns. All the sins which were done, like offenses or sins we can say, which were done during his tenure, he will be getting an immunity from it. No, during his tenure, whatever the offenses occurred, he will be still be liable. So after resignation also, any of the regulator, be it income tax authorities or enforcement directorate or any other IBC, whoever, IBBI, so who are the registrar of the companies, whoever, so the regulator, if any case or which was during his tenure happened, or it's still going on, right, he can be summoned for it. So it's a no immunity. Resignation is no immunity for any director for offences during his tenure which occurred. Where all the directors of a company resign from their office or vacate their office Under 169, the promoter, or in his absence, the central government shall appoint the required number of directors who shall hold office till the directors are appointed by the company in general meeting. So if all the directors of the company resign or they vacate their office, vacation of office, the separate provisions are there under section 167 of the act. We are concentrating here in 180, 168. So the resignation, vacation of the office can happen in two scenarios: a person resigned or person has vacated the offices, right? So 167 and 168 operates, right, together, or maybe one of the other will operate and the vacation of office will take place. So if all the directors have resigned or they are not available for work, then who will administer the company? That's the question. So in that scenario, the promoter, or in his absence, so if there are no promoters in the company, few companies are there like ITC in India who doesn't have the promoters, right? So the no promoter is there. Then in the absence of that, the central government means the Ministry of Corporate Affairs, the registrar himself, shall appoint the required number of directors. So minimum required number of directors as per 149 of the act is two directors in case of a private company, and in case of public company, three directors, minimum requirement by the act. So they will be appointing the required number of directors, means the minimum number of directors, right? Who shall hold office. So these directors will be holding the office till the directors are formally appointed by the company in the shareholders meeting. So whose responsibility is to appoint the directors? The shareholders' responsibility is to appoint the directors. So whenever the meeting, general meeting will happen, then the company means the shareholders will be appointing formally the directors, right? So till that time, these directors who are appointed by CG will serve the office and they'll work and administer the company. So this was about the resignation of director provisions. We have studied the rule, act, both simultaneously. Now let us move to the next one. So next topic we are studying is the removal of directors. Removal of directors is covered under section 169 of the Act. So a company may, by ordinary resolution, remove a director, not being a director appointed by the tribunal under section 242, before the expiry of the period of his office, after giving him a reasonable opportunity of being heard. Means removal of this office, let us understand one thing, that the meaning of resignation is voluntary, right, in nature, but removal is forceful. The superiors or the authorities can remove a person. So here the removal is happening. So whoever is the authority who is appointing a director, they only have the power to remove a director. So we have already learned that the directors are appointed in general meeting by the shareholders, right? And it's an ordinary business item of the general meeting, and all the directors are appointed by ordinary resolution. Exceptions are there in case of ID, which we will be seeing later. So here, the director who will be removed, he will be removed by passing an ordinary resolution. And before removal, obviously the director will get an opportunity to opportunity of being heard, and obviously the shareholders will be listening uh, the stand of the director as well. Now, a director who is appointed by the tribunal and not by the shareholders under section 242, obviously these directors cannot be removed by the shareholders. An independent director reappointed for a second term under 149 subsection 10 shall be removed by the company only by passing a special resolution and after giving him the reasonable opportunity of being heard. So independent directors shall also be removed by the shareholders, but here the resolution will be a special resolution because ID is appointed also through a special resolution. So he will be resigning, means removed also through with the help of a special resolution. Nothing contained in this subsection shall apply where the company has availed itself of the option given to it under section 163 to appoint not less than two-thirds of the total number of directors according to the principle of proportional representation. So there are various methods of appointment of directors, right? So if the proportional principle of proportional participation, which is given under section 163 of the Act, this is one of the method of appointment, and with the help of this method, at least two-thirds of the total number of directors has to be appointed using this mechanism. That is the principle of proportional representation. So if this director who is getting removed is a part of that two-third and he was also appointed using this principle of proportional representation, then this section 168 shall not be applicable. The removal process or the term of the directors who are appointed using this mechanism, that is principle of proportional representation, is being given under section 163 of that. So this 168 will not be applicable here. A special notice shall be required of any resolution to remove a director under section 169 or to appoint somebody in place of a director so removed at the meeting at which he is removed. Means we require two things. First is the special notice and next is the ordinary resolution in the general meeting to remove a director. And in this special notice, two agenda items can be there. First item will be to remove a person, means person A is getting removed and in place of A, B is getting appointed. So both the resolutions will be mentioned in the special notice. On receipt of the notice of the resolution to remove a director under section 169, the company shall forthwith send a copy thereof to the director concerned, and the director, whether or not he is a member of the company, shall be entitled to be heard on the resolution at the meeting. So obviously, this special notice will go to various parties who will be interested and who are eligible for attending the general meeting, right? So one of the party is the director concerned. So he is removed, so he will also get the special notice from the company. And he will be intimated that he is getting removed in the upcoming meeting. So obviously, his case can be represented by himself only at the meeting before the shareholders. So he'll get the opportunity of being heard. Where notice has been given of a resolution to remove a director and the director concerned makes with respect to that a representation in writing to the company and requests its notification to members of the company shall, if the time permits it to do so, in any notice of a resolution, give to members of the company the fact of representation having been made and send a copy of the representation to every member of the company to whom notice of the meeting is sent. And if the copy of representation is not sent as aforesaid due to insufficient time or for the company's default, the director may without prejudice to his right to be heard orally, require that the presentation shall be read out at the meeting. Let us understand this is very much big provision. It's very simple that the notice, special notice will be given to the concerned director. So after he got the information that he is getting removed, he has a right to get a right to be heard at the meeting. That's there with him. Plus, he also has a right to give a written representation to the company, and company will send this representation of the director, attach it with the notice, special notice, and send to all the members, right? So, representation in writing also can be given by the concerned director. And if the time permits, means we have a timeline in which the special notice or notice of general meeting need to be sent to the members, and we need to follow that. So if it is within the time the notice is this representation is received by the company, then company will be mentioning in the notice itself that the representation is also being attached in this notice, and also send the copy of representation to every member to whom this notice will be going, right? So obviously the direct members has the notice with them, and also the proposed resolutions, plus also the representation of the director concerned. So they are well prepared, well informed before they enter the meeting room to take the decision. And if that is the case, that due to insufficient time or any company's default, the director's representation was not did not reach the members along with the notice, then obviously the director has a right that his representation orally be heard at the meeting or read out at the meeting. In this scenario, the representation will not be sent, and also the representation will not be read out at the meeting. What's the scenario? If on the application, either made by the company or any other person who claims to be aggrieved, and this application is made to the tribunal, that is the National Company Law Tribunal, and tribunal is satisfied that the rights conferred, means the right to get a representation, written representations to be sent to the members before the meeting, which we learned earlier. So this right which is being given is being abused by the concerned director to secure the needless publicity for defamatory matter. So he wants to spread the defamatory matter, and which will obviously have a dent on the image of the company and also the reputation of other directors, co-directors, right? So that's why if the tribunal is satisfied that the person is misusing his right, then tribunal may order the company's cost on the application. So if company has made an application, company's cost has also incurred, right? The engagement of the legal counsel and also the other application related cost, right? So company's cost on the application to be paid in whole cost or in part, means the part of the cost by the director concerned, notwithstanding that he is not a party. So director was not a party of that case, but still the director has to bear that expense if the tribunal order. And tribunal will also order that this representation shall not be sent in the public to the members, and also shall not be read out at the meeting. The vacancy created by the removal of a director under 169 may, if he had been appointed by the company in general meeting or by the board, be filled by the appointment of another director in his place at the meeting at which he is removed, provided special notice of the intended appointment has been given. That we have already understood. In the above subsection 2, it was mentioned that in the special notice, two things will be mentioned. A person who is removed, right? And the person who is taking the place of that person who is getting removed. So this vacancy which is created by the removal of the director shall be filled by the another director in the same general meeting, right? And a first resolution will be passed regarding the removal of the person, person A, and person B who is getting appointed in place of A will also need to be mentioned in the notice. The resolution is already there, so obviously the members will be appointing that person in place of A in the same general meeting. The director so appointed, so Mr. B so appointed, shall hold office till the date up to which his predecessor, that is A, would have held office if he would have not been removed. So if A's term, A was appointed in general meeting, suppose, and A's term was for next 3 years, right? He was appointed for 3 years. We are taking a hypothetical example. A's term was for 3 years, and A was appointed by the members in general meeting last year. So he has just served 1 year term. So 2 year term is still pending, right? So this 2 year term will be served by B, who has been appointed in place of A. After this completion of 2 years, B has to vacate his office. If the vacancy is not filled up, means if the vacancy is not filled up by the members in the general meeting, it may be filled up as a casual vacancy. So if there is no person, they have not yet found the appropriate person who can replace A, then obviously no resolution is there mentioned in the special notice. So members will not be able to appoint anyone. So in that case, that vacancy can be filled up by the board of directors as a casual vacancy. And provisions regarding casual vacancies are given under 161 subsection 4. So board of director has the power to fill the casual vacancy. And here one condition is that the director who was removed, like A was removed by the members from office, shall not be reappointed as a director by the board of directors, because board of directors powers are there, but they cannot obviously appoint the same person who was removed by the members in the general meeting. Notwithstanding, in this section shall be taken means as a depriving a person removed under this section of any compensation or damages payable to him in respect of the termination of his appointment as director as per the terms of contract or terms of his appointment as a director, or any other appointment terminating with that as a director, as a derogatory from any power to remove a person from other provisions of this act. So here, nothing in this section shall be taken as a depriving. So a person who is getting removed, like A was getting removed in our example, so he will be getting all the compensation, all the damages which is payable to him in respect of the termination of his appointment. It will be paid by the company. Obviously, whenever a director is appointed, he is appointed using the terms, obviously he gets the appointment letter, and the terms and conditions of appointment are mentioned in it. So all this at the case removal scenario also is mentioned, that how much remuneration he will be receiving from the company at the time of termination of the office. Everything will be mentioned. So as per the terms and conditions which are mentioned in the contract of the appointment, it will be paid to the concerned director. So he will not be deprived from any remuneration or compensation or damages in the scenario when he is removed from his office. Now we have completed both the topics, that is the removal of director and the resignation of director. Hopefully everyone has understood both the topics. And one more thing to be added, that removal of director, the provisions of 169 is very stringent, and in real life practice, we can say that these provisions are invoked at a very least or the rarest of the occasions. People try to invoke the provisions of 168 rather than they prefer not to invoke the provisions of 169, that is the removal of directors, right? Because it's not a win-win strategy or situation for neither a company nor the concerned director. So it's a kind of, obviously everything is attached, reputation of the company and the volatility of the share prices, everything with respect to the appointments of these key managerial personnel and these executive directors, right? So that's why it's preferable to step down from the company as using a resignation mode and not the removal mode. So hopefully we have understood both the provisions, but in real world, these provisions are not invoked often, right? This 169. So that's all about both the topics about the removal and the resignation. Hope everyone has understood it. So thank you for a patient listening.